Welcome to Employment Law This Week. I'm George Whipple. Our top story, on narrow grounds, the United States Supreme Court found in favor of a baker in Colorado who refused an order for a custom wedding cake from a gay couple because of his religious beliefs. The Colorado Civil Rights Commission found the baker had engaged in unlawful discrimination after he refused to serve a same-sex couple. The High Court found that comments by one member of the Colorado Commission showed religious animus that violated the First Amendment's Free Exercise Clause. However, the court declined to address the delicate balance between a business's First Amendment rights and statutory protections under the anti-discrimination laws. This issue is likely to be back in court in the near future. Janene Marasciullo has more.
The Masterpiece Cake decision does not address the question of whether Title VII prohibits discrimination based upon sexual orientation. That issue was not raised. However, there are signals in the decision that indicate that the justices may be receptive to that argument. One of those signals being it was a 7-2 decision. And all 9 justices, even the 2 in dissent, recognized that gay people are entitled to the protection of the law.
The California Court of Appeals says waiting time penalties apply regardless of whether there was malicious intent. Labor Code Section 203 states that an employer who willfully fails to pay any wages after an employee is terminated or quits is responsible for continuous wages until payment is made. In this case, the employer argued that its failure to pay was not willful because it was not aware of a minimum wage hike. But the court determined that ignorance of the laws was no excuse, and that willful failure to pay only requires that an employer act knowingly. The Supreme Court's epic decision sends a slew of class action cases into individual arbitrations. In light of its landmark ruling that okayed class action waivers and arbitration agreements, the High Court has remanded a pending United Healthcare class action case back to the 7th Circuit. A Michigan federal court just ruled that workers suing Fiat Chrysler for discrimination will have to take their claims to individual arbitration. And a California federal judge did the same for a class of delivery drivers suing a Domino's franchisee. 2 more states say no to salary history inquiries by employers. Connecticut and Vermont are the most recent states to prohibit employers from asking applicants about their salary history. The Connecticut law allows applicants to file lawsuits against employers who inquire about their past compensation. Vermont's law bans salary history questions but allows employers to ask about an applicant's salary expectations or requirements. Now, it's time for our tip of the week. Ann Burns, Chief Human Resources Officer for Higher Logic, is here with some tips on providing productive management training.
What manager training can do for all managers is really provide an opportunity for skill building, for an opportunity to look at company policies and procedures, make sure that your managers are aware of what their responsibility is to the company, as well as what their personal liability is in situations that they act appropriately. Another opportunity is identifying the management group for which you want to do the training for. Some companies will decide that you want to do different levels of training for different groups of people. This year, my company decided to do all managers at the same time, just so we had the opportunity to baseline all managers. We acquired 4 companies this year in 3 different states. So we decided providing the opportunity for all managers to come to our headquarters for a 2-day workshop was an effective way to kick off the program and meet our goals.
Thanks, Ann. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.